So the Ninth Circuit has issued a Pro 2A decision which is already impacting the Miller v. Becerra California assault weapon ban case, which is currently in front of Judge Benitez. So let's talk about this. But real quick before we jump into this video, if you think California's ban on so-called assault weapons is clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to thank one of the sponsors of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. Some of their dedicated roasts for GOA and FPC, if you order those, some of those proceeds go directly to those organizations so they can file lawsuits like this one. So again, check out Blackout Coffee, amazing coffee, and if you use the code ARMSCHOLAR, you can get 10% off of your order. So as I mentioned in the intro, in this video, I have some updates for you in the California assault weapon ban case called Miller v. Becerra. The Miller case just received huge support from a recent 9th Circuit Pro 2A decision that was issued by a 3-judge panel. Recently, a 9th Circuit 3-judge panel issued a decision in a case called Tedder v. Lopez. In this case, the 9th Circuit was reviewing a state of Hawaii law which made it a misdemeanor to knowingly manufacture, sell, transfer, transport, or possess a so-called butterfly knife. Essentially, this law was an outright ban on butterfly knives. In the decision, the 9th Circuit panel found that the possession of butterfly knives is conduct protected by the plain text of the Second Amendment, and that Hawaii has not demonstrated that its ban on butterfly knives is consistent with this nation's historical tradition of regulating arms. Therefore, the 9th Circuit issued a decision finding that the state of Hawaii and their butterfly ban did in fact violate the Second Amendment, so they reversed the lower court's decision which ruled in favor of the state of Hawaii, and then they remanded the case back down to the lower court, telling them that they need to actually rule according to what the 9th Circuit just said. This decision by the 9th Circuit is critical, and I cannot emphasize this enough because it is the first Second Amendment decision that we have got in the 9th Circuit, and essentially it's the first one after the Supreme Court issued their 6-3 decision in the New York State Rifle and Pistol Association versus Bruen case. This decision sets strong Pro 2A precedent in the 9th Circuit that is now being used in the Miller v. Becerra California assault weapon ban case, which is currently in front of Judge Benitez. Now, for those not aware, Miller v. Bonta is a challenge to the state of California's ban on so-called assault weapons. Under California Penal Code Section 30515, the state of California bans various types of firearms based on their characteristics. For example, a semi-automatic centerfire rifle with a detachable magazine cannot have something like a flash hider, a collapsible stock, or a forward vertical grip. There are some accessories that, if you have them attached to your rifle, all of a sudden, under the California definition, that rifle then becomes a so-called assault weapon. In the original review of this case, Judge Benitez found that this case was an average case about average guns used in average ways for average purposes. In reaching his original decision, Judge Benitez used a standard of review that has now been expressly affirmed by the Supreme Court. He looked at the text of the Second Amendment and the history of our nation, and ultimately he determined that the state of California's ban on these types of firearms or these types of arms is in fact unconstitutional and violates the Second Amendment. Now, after he struck down California's assault weapon ban case, that was a granting of a motion for summary judgment in favor of the plaintiffs, the state of California then appealed that decision up to the 9th Circuit. Eventually, the Miller case, along with other 2A cases, were remanded back down to Judge Benitez after the Supreme Court issued their Bruen decision. It is this standard which was outlined in Bruen which is now being applied by the 9th Circuit in the Tedder case, and it is this analysis which will also be applied in the Miller case by Judge Benitez. In Tedder, the 9th Circuit stated that the panel held that possession of butterfly knives is conduct covered by the plain text of the Second Amendment. Bladed weapons facially constitute arms within the meaning of the Second Amendment. And contemporaneous sources confirm that at the time of the adoption of the Second Amendment, the term arms was understood as generally extending to bladed weapons, and by necessity, butterfly knives. The Constitution therefore presumptively guarantees keeping and bearing such instruments for self-defense. The panel held that Hawaii failed to prove that the law was consistent with this nation's historical tradition of regulating weapons. The majority of the historical statutes cited by Hawaii did not ban the possession of knives, but rather regulated how they were carried, and they also concerned knives that were distinct from butterfly knives, which were more analogous to ordinary pocket knives. Hawaii cited no analogs in which Congress or any state legislator imposed an outright ban on the possession of pocket knives close in time to the Second Amendment's adoption in 1791 or the 14th Amendment's adoption in 1868. So the two big things that the Ninth Circuit did in that Hawaii Tedder case was first clearly state that butterfly knives are arms and the possession of them is conduct protected by the Second Amendment. The court then rejected the state of Hawaii's historical evidence that they put forward and they tried to use to justify their outright ban. The Ninth Circuit found that there was no historical evidence or no analogs dating back to 1791 or even after, which supports an outright ban on the possession of pocket knives like butterfly knives. It is this application of the law that is now being used in the Miller case to support Judge Benitez also striking down California's outright ban on the possession of things like AR-15s and other rifles. Now, I will also note that in my opinion, the Bruen analysis really isn't even needed in California. Under Heller, outright bans on common arms owned for lawful purposes should be automatically rejected. However, the Bruen historical analog test and the historical approach in Bruen just further shows how these states like California have no constitutional support for these outright bans that they have in place. Now, in the supplemental letter which was submitted to Judge Benitez in the Miller case, the plaintiffs argued that first, the Ninth Circuit held that the historical research required under Bruen involves issues of so-called legislative facts, those which have relevance to legal reasoning and the lawmaking process, such as the formulation of a legal principle or ruling by a judge or court, rather than adjudicative facts, which are simply the facts of the particular case. Accordingly, the determination of this case did not turn on the adjudicative facts to apply the standard required by Bruen. So they're hinting at the approach that California and other states like Hawaii commonly are taking, where they're saying that they need more fact-finding, that they need professors and more statistics and evidence and all of these things that they need to get together. Oftentimes, they're trying to buy more time. There, the Ninth Circuit said, no, that's not actually the type of historical analysis and the things that need to be done in these cases. Instead, someone like a judge in the Ninth Circuit or even Judge Benitez can do the historical test which is required by Bruen. Then the supplemental brief says that second, the Ninth Circuit noted that the state of Hawaii's historical analogs were insufficient to carry its historical burden under Bruen, and that the vast majority of the statutes cited by Hawaii did not ban the possession of knives. They regulated only their carry. True, 4 of these statutes, by our count, banned the possession of slung shots, metal knuckles, and undefined category of deadly weapons, but no statute cited by Hawaii categorically banned the possession of any type of pocket knife. This supports plaintiffs' arguments in this instant case that most of the dangerous weapons statutes offered by the state of California pertain to the manner of carry or other conduct, and not a ban on the possession of such weapons themselves. So here what the plaintiffs are pointing to is the Ninth Circuit rejected the use of evidence that Hawaii tried to put forward, saying that the evidence did not actually prove an outright ban. It did not support an outright ban. Simply, it just showed maybe some type of regulation on the type of carry of certain weapons, but it did not support an outright ban. In the same way, this type of evidence that California has put forward in Miller maybe only shows some sort of restrictions on what type of weapons could be carried or used maybe in certain ways, but it does not support an outright ban. So this is really good news coming out of the Ninth Circuit, and even better news for the upcoming decision in the Miller case. Shout out to Stephen Stambuli, Alan Beck, and all the other Pro 2A attorneys who were in the Tedder case, who represented the plaintiffs in the Tedder case. I know Stephen personally. We've spent time together. He's an awesome attorney. So big shout out to him and this huge win. And again, we will see how this plays out, but this is good news going forward for all these California cases which are currently being litigated and all the big ones that we're waiting for like Miller, Duncan, and Rody. So if we get any more information, I will let you all know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.